only reason she won't lock me up, I just want to know if it still apply.
Okay.
She said if I do two things, if I plead the fifth, and I say that I killed Donovan Thomas.
Okay. I don't care if you throw me in jail. I'm not saying a word. I am not getting on the stand.
It depends on how I wake up.
Okay.
Day 106 of the Young Thug YSL RICO trial was interesting. Lil Woody comes in court and gets asked if he wants to testify again. The judge also says they are completely restarting on Woody's testimony. The judge still has to rule on motions for a mistrial and fair trial, but I can already tell she's going to deny it, honestly, and the trial is going to continue next week with the jury coming in. So join the channel membership. It's only 10 cents per day. Hit subscribe. Here we go, boys.
Here, Your Honor, the state did not violate the professional rules of ethics. We didn't violate Rule 4.2a regarding communication with an unrepresented person. The court has heard the testimony of Mr. Melnick, and the court can gauge the credibility of the witnesses after Attorney Melnick informed the state that he represented Mr. Copeland, had no further conversations with Mr. Copeland about the subject of this case without either Attorney Melnick or Attorney Bumpus present. And in its response to Mr. Melnick's email, the state agreed it wouldn't communicate with Copeland further, but noted that we had arranged for transportation and that an investigator would pick Mr. Copeland up the following morning for his court appearance. 2 judges so far have concluded it was not improper. Disqualification is not an appropriate remedy under any event, especially given all of the circumstances here. We would ask that the court deny the defendant's motion to disqualify. And if there are other grounds, we would ask that the court, if they bring other grounds, we would ask that the court require that they list out all of the grounds that they're seeking so that we can address them at once, Your Honor.
So she's saying the 2 grounds to disqualify prosecutors in other cases they didn't do. But yeah, the prosecutors totally didn't coerce Woody to testify or anything.
Well, I think both Mr. Weinstein's and Mr. Schart's motions that are pending right now, Mr. Weinstein's for a mistrial and Mr. Schart's for a fair trial, set forth additional bases and suggest that as one of the potential remedies or grounds for relief. So
Let's look at Thug on day 106 right here.
profits are fine unless one party objects, in which case then you need to present evidence. And so phone calls, jail calls.
Now we're discussing Woody jail calls. Lil Rod is literally asleep.
I went back and reviewed what all we covered.
Okay.
Got through the 5 jail calls to state of Tennessee.
Pretty sure this guy got convicted of murdering someone, so can't feel too bad for him, but they have to wake up at 4 in the morning. He's already in jail for life, Lil Rod.
Mr. Copeland gave testimony prior to the motion for recusal and then further testimony following the motion to recuse. And we all kind of agreed, okay, things that occur after a ultimately granted motion to recuse basically need to be redone. But if everybody can come to agreement as to, these things, these parts of the testimony are okay anyway, then y'all can by agreement say these parts are okay.
I thought the law already said that anything after the 12th recusal motion is invalid. So I guess she's just asking for input here.
And we can move forward. So have y'all gotten together now that I believe you have all of his testimony thus far to decide what, if anything, how to handle it? Does somebody want to represent to the court what the defense position is, if it's a joint position?
The stance is that everything post the recusal needs to be redone.
Okay.
Just because we feel that that's the applicable law.
I apologize for interrupting the court. I think there's one more party there.
William Stillwell, Kendricks, Huey Ryan. Oh, guess, I don't know. Sorry. Nichols.
Poor Nichols, always asking to be severed, and here she goes forgetting about him.
The forgotten person in this case who should be severed and who continues to object.
It's not, I'm just laughing at the situation. Obviously, it's difficult with a real person's life, and he has to go in there every day, but
It's my understanding that everybody has joined in the position that Mr. Copeland's testimony was coerced based on what occurred during the June 10th ex parte. So, and yet I know at least some of you want that testimony and said that yesterday. So are you waiving the issue of its potential coercion?
that's kind of funny. Obviously, a lot of defense lawyers say that was coercion, but at the same time, they think it helped them, so they want to keep it.
And good morning again, Your Honor. I am not waiving that
All right.
issue.
So then how do we handle that?
I thought it's to state I was answering your question. If Mr. Copeland resumes testimony, then my understanding of the rule is, or the law, is the way that the court announced, and I think all parties understand it, that once that motion by the Honorable Douglas Weinstein was filed on the 12th, everything thereafter is excluded, and we redo it. And that's what we, Mr. Atkins sent an email last night, and that's what 3 of us responded to. Intimidated, coerced. And if yes, we were going to ask you then, if a witness was intimidated, that he should not have to testify. He could choose what he wants to do, and then we would strike everything.
Okay. Well, then let's go ahead and find that out. I mean, can you get him here so that we can...
Oh, they're going to ask Woody if he feels like he was coerced to testify. And if he says yes, they're going to get rid of everything. Miss Love is standing up. She's not going to like any of this.
Everything after June 10th, whether the recusal motion was filed or not, that's kind of a separate issue. Whether his testimony post June 10th ex parte meeting was coerced. And if it was coerced, what then? Then how do we still say, oh yeah, but I want, some of that testimony? That's still good.
that we will find out whether Mr. Copeland actually wants to testify, continue testifying, and then if he doesn't continue testifying, my understanding of the law is then he would never have been given an opportunity to be cross-examined.
Right.
And therefore you strike all of his testimony. Then you give the command to the jury, wipe out everything that you heard, saw. There were writings introduced, all exhibits were struck. Give me your notes.
Right.
That's what I thought. Now,
Okay, I just didn't understand because, and thank you for clarifying, because what I was trying to sort out is, are y'all kind of taking the position it was coerced, we have to redo all of it based on the coercion, but then also, yeah, we want to keep parts of it anyway. So if it's a, yes, if it was coerced, then we need to redo all of it, or, find out, does he at this point kind of redo are you intending to take a stand and testify, or are you going to be held in contempt?
that's what I thought.
Okay, all right, just so sounds like then we're on the same page. Just wanted to make sure y'all weren't wanting it kind of both ways.
We're looking into whether or not his testimony was coerced.
Mm-hmm.
I would ask that the court not revisit or go back and see, have a hearing on whether or not.
Okay, so this isn't a revisiting of the issue because the issue is live and still pending before the court in Mr. Kendrick's motion and supplemental motion for mistrial. And
Yeah, what is Miss Love yapping about? How is this revisiting coercion? She's still trying to rule in motions for a mistrial. Woody's testimony is the center of all of it.
big claim in both of those motions. And I mean, I just gave you to Friday to respond to them, but, and yeah, I think that on the record, it's a legal determination to be made. We don't necessarily need to hear from Mr. Copeland because I'm not sure about Mr. Copeland's credibility on anything anyway, but
I'm in agreement with the judge. She doesn't think Woody is credible at all either.
notion that he could be held until the trial of even the severed co-defendants was completed, I don't think is a correct statement of the law. If you believe that it is, then please provide me with what you're basing that belief on. I think that some of the assertions about statute of limitations potentially were incorrect with regard to crimes based on statute of limitations. I mean, there's the immunity issue, which is wholly separate, but y'all were basically saying you don't even have to worry about it for the statute of limitations reason. They're saying, well, then how are we sitting over here charged with RICO for crimes, the statute of which, when the statute has run on the overt acts, they're in support of the RICO.
Ooh, that is contradicting. They're yapping to fucking Woody about having the statute of limitations ran, but then they're charging people with the RICO statute, which is 5 years in Georgia, by the way. But yet they're still charged from shit 9 years ago, pretty much, is a lot of this.
I mean, some of the this is or isn't perjury things are a little, I don't think, quite exactly accurate either.
Yikes, a lot of inaccurate stuff, coercing a witness to testify.
So, I guess what I'm saying is you run a lot of risk, even if I say it wasn't coerced, if that is the legal determination I make. I mean, I'm saying it's a really close call. And it might be better to just pretermit that issue and deal with it a different way.
Mr. Zachary's statement, his statement that I did.
So now they're about to talk about Quindarius Zachary's statements. Quindarius Zachary was a straw gun purchaser for YSL. Don't hold me to this, but I'm pretty sure he also spoke a little bit to feds, but don't hold me on that. There's so many names to keep track of.
Are you planning on playing, if allowed, the part where he talks to the 18 feds about the guns?
Okay, well, never mind. Immediately after I say that, he did talk to the feds about the guns.
Not everything that he says in these sessions is based on what arguably a co-conspirator said to him. So some objections may be it's improper character evidence, it's irrelevant, things of that nature. But there is a lot of things that he was told, and quite frankly, Your Honor, there's some that know him to have allegedly been present for something, and the source of his information is unclear. It may be rumor, it may be something he was told, and that's probably something that we're going to need to wade through at some point.
Okay.
So it sounds like some of Quindarius' statements to the feds might be a lot of hearsay.
All right. So the very first one is I'm about to tell you something, and I've just said I wasn't there. So it's obviously hearsay. So what's our exception? All right. So are you good with the redaction of 11 line 10 through 12 line 10? Have you had a chance to look at these proposed redactions yet?
I looked at them. I haven't synced them up with my transcript in my
Okay.
So because I've read the transcript and listened to it so many times, I'm going through it with that knowledge.
Okay.
I haven't.
So she hasn't synced it up, so she's not too prepared, which I get. I mean, everyone's busy as shit, but
And
Unless if I don't establish that foundation, I won't tender that. But if I do, I just want to be able to play that part about his.
okay. So how about this? Right now, it's out on the granted as to speculation.
Okay.
And if you establish it,
Okay.
then that'll be a different story.
oh boy, she's starting to sound like Glenville. She's like, all right, it's out right now, but if you establish enough foundation, it can come in.
My objection is drug use, and the character that's associated with that, and the statement they really didn't care. Speculation about someone else's mind state or state of mind. The reality is, within this context, is a story about that Mr. Zachary gives that he describes my client, as well as others, shooting up houses. And I'm not,
Yikes, I can see why Schardt doesn't want that in. He's talking about Shannon Stillwell shooting up houses.
of course, I don't want that to be admitted, and that's a fight for another day. But I'm not objecting to that on any of these bases, but I am objecting. So I'm not objecting to him talking about that at this time, but I am objecting to him pontificating about my client's state of mind as this was going on, because he can't really speak to that.
So that would just go to the they really didn't care part. And then you're saying the fact that he's saying they were taking Xanax is...
I don't know his basis of knowledge of that, but I don't believe that to be true, but I don't know his basis of knowledge of it.
So Schardt doesn't like him talking about Shannon Stillwell taking some Xannies.
He is in the car with the persons that he's speaking to the detectives about. He has the opportunity to observe them up close. The question posed, as the court can see, is did they feel some kind of way that you didn't get out of the car? We believe that the evidence has shown and will continue to show that these people he's in the car with that are shooting up these houses are his friends. He's known them for a long time, and his personal observations of them and personal knowledge of them is what allows him to make the assertion that he does as to why they didn't care that he didn't get out of the car while they're facing arguably danger. They're the ones getting out, according to Mr. Zachary, doing the shooting, but they were high, essentially. So that's the reason why they didn't mind him not getting out of the car. We'd argue that it's intrinsic. It could go to why they would be so brazen as to do something like that. But the fact that they were high while they were shooting, the fact that it incidentally touches on someone's character.
Okay, so I don't have I don't think I'm going to overrule it as to character. And if you can establish that he actually knew they were on Xanax and high.
Same ruling as last time.
Mr. Zachary is asked by the prosecutor, what was you all's intention when you all headed over there? He says that we were going to kill one of the boys. And then the prosecutor says, and one of the boys, I know we talked about a bunch of names, but which of the guys were you looking for? He's specifically talking about their intentions when they went on this shooting spree. I think that it's not only relevant, intrinsic, it gives a motive for what they were doing. He has personal knowledge of it. He was in the car. They were riding together.
Okay, well,
Jesus. Quindarius Zachary was definitely speaking to the feds a little bit too much, boys.
as you establish that he knew that's what they were
Okay,
planning
she's
to
going to be a broken record all day, just establishing foundation.
My client was never charged.
Okay.
Mr. Zachary is throwing my client's name into this. And I understand that's subject for cross-examination as well. But when he says, what was y'all's intention? Now, it strikes me that Mr. Zachary can speak to his own intention, unless he says Mr. Stillwell was there and this is what Mr. Stillwell said or something of that nature. He can speak to his own intention, what his intention was, and the state can ask him on the stand, Mr. Zachary, when you went over to the house, what was your plan? But unless someone else articulated their plan to Mr. Zachary, I don't think he's authorized to speak to what anyone else's plan was.
I understand, and it may very well be that you can establish that they all had a joint intention because they had some sort of talk about it beforehand.
And they actually he reveals earlier in the interview that they do discuss it.
All right, so where's that?
Investigator Dennis asks, why does Moontoon, and that is actually Antonio Sledge, it's spelled wrong, tell you not to get out of the car? He said, Mr. Zachary said, because he said, we don't shoot up houses, leave that to them. That's one point that they're talking. Further back on line, page 24, when Mr. Zachary is talking to Detective Dennis about the kind of guns that they have, he's naming them.
Okay, I mean, it does look like they kind of had.
Well, Your Honor, he's talking about what Moontoon said. Moontoon's not even here. My client is not Moontoon. And so I don't find respectfully what Ms. Love said to really address the issue.
All right, so where is it that your client gets, what is it that is indicating that he's talking, his speech includes your client if your client's not in the car?
No, my client is supposedly in the car according to Mr. Zachary. But what Ms. Love talked about is Moontoon telling Mr. Zachary to not get out the car, saying we don't shoot up houses, leave that to them. What that has to do with my client's intent to kill someone, I'm not seeing that link at all. And my whole point is this, Your Honor, if they can establish through Mr. Zachary that my client indicated what the intent was, what the plan was, that's not in this transcript. That's going to come across through live testimony, which would render prior statements, out-of-court statements, irrelevant anyways, because it would have been established through live testimony.
Right.
So I don't know why we would keep this in the transcript.
Judge, I thought that the whole purpose of this exercise was assuming that they don't.
It is. Okay, so assuming you need to use it as a prior inconsistent.
Yes, and in response to Mr. Schardt.
Schardt kind of fucked that up. He didn't realize they're just going through everything in case they have to use it as a prior inconsistent statement. This is kind of strange, though, because it's Quindarius Zachary supposedly hearing something Moontoon said about Shannon.
Statement is just based on assumptions he's making through the actions of others. Then the jurors are in a similar place as Mr. Zachary to draw that conclusion.
But Mr.
Zachary, I don't understand why Mr. Zachary, his conclusion about what my client's intent was particularly helpful or relevant to anything, unless my client articulated it to him.
The reality is that an assertion by a co-conspirator, if everyone is acting towards the same goal, people are getting shot up, houses are getting shot up, and
With assault rifles that are in the car.
Right.
Yeah, I'm going to overrule that.
Judge letting a lot of stuff in, man. Not a good look for Shannon Stillwell, at least. Statements about Shannon Stillwell shooting up houses with guns in the car.
Quindarius Zachary about activities that YSL and rivals are sort of involved in. Mr. Dennis
The judge is definitely letting that in.
talks about how they thought it was Kale, and Mr. Zachary says no, but Zachary later on line 17 says they tried to say that we did it, acknowledging that there is a we, acknowledging in a way that helps to prove count 1 in our indictment. There is a they who is an opposition group who tried to say that we did it, we being YSL.
Where is the part where the opposition group is saying they thought we did it? I see the investigator saying we thought y'all did it, but
No, line 17 where he says they tried to say that we did it on on page 33.
oh, it's back on page 35. I'm sorry. Establish.
The existence of the enterprise, the gang, and the fact that there is an opposition and a they and a we.
All right, Mr. Schardt.
I mean, that's not factually accurate.
Shard saying she capping.
With this alleged incident, the shooting up the houses, Mr. Zachary also puts a gentleman, two gentlemen, a Trevante Turner and a Tay, being in the caravan with them shooting up these houses. Trevante Turner is sadly deceased. He has never been, I've never heard anyone allege that he was a member of YSL. The paper just reported that he was associated with, I believe it was If Gang.
I'm not sure I'm going to go on what the paper says.
I understand, but the state has never alleged that. He's not charged in this.
Okay.
This is a gentleman who has not, there's been no allegations that he's been affiliated with us. I believe there's a suggestion that he's a friend of Kenneth Copeland's, but that's it. I mean, I don't want it to come in, but I don't have a legal argument at this point against Mr. Zachary saying Trevante Turner was part of this mission that he's claiming existed. But at the times that I highlighted that I have a problem with, it's talking about a wholly unrelated incident. Trevante Turner, who's not one of us, and Shell Cal, who is Kelvin Watts, were having their own side beef and shooting at each other. And I believe Trevante was shot maybe by Shell Cal. Mr. Watts was maybe shot by Trevante, but it has nothing to do with this indictment. It's not alleged as an overt act.
Okay, I'm so sick. This is something I have an issue with right here. There's so many shootings that are coming up in this trial that are not listed as overt acts. They shouldn't be allowed in. I'm sorry.
This incident would have nothing to do with that. And it's just talking about, and they're just really treating it as small talk. You know, he's telling a story and then it's a little aside about Trevante, which has nothing to do with this case.
That he is an associate of YSL/30D. Just to go to the assertion that there's never been any indication about Trevante Turner being YSL.
Well,
but
an associate of YSL and a member of YSL aren't the same thing.
they aren't. But I'm not asserting my argument that in saying they try to say we did it, he's not just talking about a random group of men. He's talking about them as a group that operates as YSL is the argument that I would make.
Well,
Who's the they here? This is
Associates
part of the
of,
gang
yes.
that there's the alleged beef back and forth and the series of shooting. The members that are involved in this little, even if it's a side incident, are all that gang?
Yes.
Okay.
well, if that's the money line, they tried to say, like, how's that admissible? They tried to say we did it. I mean, false accusations by an unnamed group.
It's such a big reach. Once again, they try to say we did it is the reason why it comes in.
Declarant, in this case, Mr. Zachary, is actually saying they were wrong about. How's that admissible to anything? You know, and if that's the key section, that's inadmissible of itself, wholly irrelevant, and it confuses the issues.
And a group that he belongs to.
All right. So,
He's literally saying no, that didn't happen.
right. But she's not offering it for whether it happened the way they said it happened or not. She's offering it for the concept that Mr. Zachary is saying, yeah, there's this we here that is YSL. And that is certainly relevant to the issues in this case.
They've already established a we and a they in this trial about 50 times. Do we need more we and theys evidence? And Lil Woody is here to clarify if he feels like he was coerced, I think. Or if he's going to testify again in general and not plead the fifth. Like, who knows?
I'm Judge Whitaker. I think you've been before me before in unrelated matters. I'm the judge taking over this case now. So go ahead and have a seat. What I want to ask you right now, I know that you have been given immunity with regard to your testimony. And there had been, at some point, you didn't want to testify. At some point, you did want to testify. The first question I have for you.
I know when to be testified.
Okay. The first.
I never want to testify.
Well, right. Want to is maybe the wrong term. But my question for you right now is, do you have an attorney at all?
I don't know.
You don't know whether you have an attorney. I would think that would be a no then if you don't know
I
whether.
was talking to Melanie, but
Melnick?
yes.
Okay. Didn't he ask to be relieved as your attorney, and did you sign something saying that's okay, you can get out of this?
I don't
You don't remember? Okay. Does anybody know whether that actually occurred?
I don't believe it occurred.
See, is he acting dumb, or does he really not know if he has a lawyer officially right now?
Some of what I suspect you recall when you were brought into Judge Glanville's chambers with Ms. Bumpus and a couple of the people from the state, and there was a discussion that Ms. Bumpus and Ms. Hilton and Judge Glanville had with you. You asked some questions. They gave you some information. Some of that information was not actually factually correct. And I want to make sure that you have the opportunity understanding what it is that the immunity order means, understanding.
Oh, this is going to be very confusing for him. He didn't know the difference between purging his contempt and perjury. And now he's being told that what he was told about statute of limitations is wrong.
The potential consequences are if you do testify or if you don't. We're basically going to kind of start over and
So if
do
I
that
don't
over.
testify,
Huh?
so if I don't testify, how long do they hold me in jail?
So, I mean, that's still an issue that you can be held in jail through the end of this trial. But I'd rather have Mr. Melnick here to advise you about the potential drawbacks of and benefits of what, if there are any,
This
of any
trial
of
right
your.
here? To the end of this trial?
Yes.
Not the other people.
As far as I believe, but the state, what, did you want to do some further research on that?
Yes, just to advise the court of.
Look at the state trying to keep Woody in there for years. That's crazy. No. He can stay until the other guys are tried that don't even have lawyers yet because there's not enough lawyers for all the defendants.
I just wanted to know, first off, do you have an attorney? Because if you do have an attorney, then your attorney may have some information, advice, and research for me about that. So I want to make sure that I tell you the correct thing about that, okay? So we're going to take a lunch break in a little while, and why don't we plan to have you back here on standby at least?
She was emphatic that Mr. Melnick said, if you testify, I'm not representing you. So, and with the fact that Mr. Copeland said,
I think Mr. Melnick did actually say that. If he testifies, I won't be his lawyer anymore. I think I remember that.
I'm not representing you. So I don't know, what that means. I'm just going to reach out to Mr. Melnick, and at least Mr. Copeland thinks Mr. Melnick is still representing him. And if Mr. Copeland never signed whatever that was relieving him.
Your Honor, having a case on point, however, it would make logical sense that it couldn't have passed into the trials. How Mr. Copeland heard himself contended that interim time change to trials.
Yeah, I mean, I guess the same way that they suggest that if the grand jury is over with, you can come purge yourself by testifying in front of the court.
That is true. If they hold him for all the trials, right? If they hold Woody in jail for all the trials, and this trial ends, how can he purge himself from the contempt if there's no trial in between the other trials that are going to start later on? There's no trial for him to even purge himself if he wanted to come testify. That's like insane. He would literally just be in jail for no reason, not able to purge himself of his contempt.
I'm sort of going with through the end of this trial unless somebody tells me differently.
That's the right ruling. It should, if they want to hold him in contempt, it should only be this trial, not other trials where they don't have their lawyer.
The example, and I know what Ms. Hilton means. I don't think that anybody is purposefully trying to mislead anybody. I think we're all, you weren't there by the time Mr. Copeland came in, but I think Ms. Bumpus, Judge Glanville, and Ms. Hilton were trying to make sure he understood.
See her attitude with that? They were just trying to explain Woody his immunity deal and purging his contempt. That's it. There was no coercion. She's going to deny all this shit and the trial's going to move on, obviously, in my opinion.
What if I said I did something and I know you didn't do it and you said before you didn't do it? That's not perjury. That is a prior inconsistent statement. Well, I mean, yes, it's a prior inconsistent statement, but it might also be perjury. It might not be, but there'd have to be some, proof that it's a lie. And he clearly, I don't think, understands. I mean, he even says, I don't understand any of this at the outset. And, we're talking about purge versus perjury. And
yeah, you need to explain it to him again. A clear, concise paragraph and go sentence by sentence and look at Woody like he's 5 years old and explain everything to him.
The federal statute on contempt related to kind of their version of immunity is that the confinement can't exceed the life of the court proceeding. So that's sort of, I know we're not the feds, but
is court proceeding the indictment or is it the trial of a severed? Because if people are severed,
I don't know the answer to that.
Come on, Miss Love. Really trying to keep Woody in there for years, bro. I hate her so much because she knows if Woody hears, oh, it's only 6 months, probably this trial's only going to last another 6 months, maybe. And then I get all this good publicity when I get out because people are like, hey, you didn't snitch.
The contempt is punishable for this trial. And after that, we don't do for other trials that are not set. And the government can't continue the same contempt over and over again. They can bring an obstruction of justice indictment against the person or a contempt criminal charge against the person. But we don't just hold people because it becomes, and there's other case I can send you, at some point it becomes just punishment. The whole point of civil contempt is to coerce the person to do the act.
Right.
And at some point they're not doing the act.
Yeah.
Otherwise, according to Ms. Love, I mean, really, according to Ms. Love's reading, we could just hold them until it's 50 years later. Yeah.
Yeah.
I mean, at
which
some
can't
point,
be the law. And I know you're not arguing that.
Mr. Steele thankfully found something that says otherwise than what Miss Love is saying. Oh, Mr. Matthews got another one.
A trial court, however, may not continue incarceration for civil contempt when the respondent lacks the ability to purge themselves. Imprisonment under civil sanctions is always conditional, and a party found in contempt may apply for release at any time upon a showing of inability to comply. The moment it appears that there is inability, it would clearly be the duty of the judge to discharge the party because the purpose of civil contempt is to provide a remedy and to obtain compliance with the trial court's orders. The justification for imprisonment is lost when the compliance is impossible.
Thank you. I think you have hit on the exact case we needed. So that answers the question for me.
Mr. Matthews snapped. Let's go. Them trying to keep Woody in jail for all the other trials is insane. Like, those trials probably wouldn't be done until 2026, maybe. I don't even know. Maybe even later. Maybe in 2027.
Look all you want, Miss Love, but I think that pretty clearly answers the question. Logically speaking, that was kind of what I was feeling anyway, but now we got case law backing up.
Now we got Mr. Melnick here in a Zoom call.
Determined somewhat with agreement of the parties that we are just going to start over with Mr. Copeland. And
I can't believe this trial is going on. How is this trial continuing with all the corruption?
So I've talked to him about all that stuff.
Okay. And so are you his attorney currently?
I am his attorney. Yes.
Okay. All right. So, and you're representing that you have in fact already advised him of all of those things?
Yes.
Okay. All right. So
it sounds like Woody understands everything. Let's go, boys.
Yes, Judge, can we inquire as to whether or not Mr. Melnick, and I'm sure he has had an opportunity to discuss with him any potential federal ramifications he may have in regards to his testimony here?
Object to counsel for the defense.
I've asked them to raise anything that they think we ought to be thinking about. So
Yeah, what, Miss Love? She just asked for their input, and she's about them bringing up federal prosecution on Woody.
I invited them to say that. So I don't know whether you want any additional
Shut
time,
up.
having heard that potential issue, Mr. Melnick.
Here comes Woody, boys. Here he comes.
All right. Hello again, Mr. Copeland. Your attorney, Mr. Melnick, is with us by Zoom right now. You can see him on the video screen and he can see you. If there's any time you want to talk to him privately, let me know that. Compelled to testify because we are acknowledging that anything that you say, we cannot prosecute you for a crime other than perjury or false statements based on something that you might say that would otherwise incriminate you if it weren't for this immunity order. And if knowing that you still choose not to testify, the court can and will hold you in contempt. And what happens in that event is that you go to jail. And the length of time that you could be held in jail for, if you don't change your mind and say, okay, I guess I will take the stand, is through the end of this trial. I don't know how long it's going to last. I think previous projections had been February or March of next year, but it would only be through the end of this trial. It would not be through the end of whomever else might be severed from this case and tried later. And I know Mr. Melnick's talked to you in more detail about that. So I want to see if you have any questions of the court about that.
I didn't understand. Now you said at the beginning.
Here we go. He doesn't understand anything.
All right. So
No, I'm saying, like, I heard you, but I don't know what you're talking about.
okay. So tell me what it is that you'd like more information about.
You said something about what they said about immunity?
Yeah.
What you mean?
Okay. Does anybody, I think I've got the order. Mr. Melnick, have you reviewed the immunity order with him?
Oh, you saying it's the same from last time?
Hang on a second. Yeah, the same one as last time. Yeah.
Yeah.
This one. So that's the one I'm talking about. And that is still in effect.
So you're saying that changed?
It has not changed. So what has changed is it's my opinion that I cannot hold you in jail if you refuse to testify beyond the end of this trial. I think you had maybe been told something different earlier, and I don't think that is
So I ain't got to wait till every defendant gets not here.
correct. But you would, if you choose not to testify despite this order, you would potentially be held in jail through the end of this trial, which might be February of next year, might be March of next year. I really don't know. It ends when it ends. And the state has 100 more witnesses, and I don't know, any defendant might also have witnesses. So it could take a while, but that would be the end of it, would be the end of this trial. So do you have any other questions?
Mm-mm.
Okay. And it's something the state knows and can prove. They can charge you with perjury or false statements, but they can't, if you say, if you incriminate yourself about another kind of crime, they cannot use that to charge you with a crime. And they can't say,
Well, can I speak?
you can,
I
yeah,
have
if you
told the
have
state.
Huh?
I have told the state I have lied and lied and lied and lied.
I know. And,
So how are they going to be able to question me?
I mean, that'll be their problem. That's their case to make or not make. I mean, that's not for you or me to worry about.
This is literally the worst state's witness I think I've ever seen. And this is their star witness that connects a lot of people to murders.
So
They said they're going to be able to charge me if I lie. Like, when they just up to them to choose when I'm not.
not prior. You've said you've lied and lied and lied in every, I don't know what you've said, but let's even say you've said you lied in every statement you ever gave to the police. If you get on the stand and say that again, or if you say, all right, this one was the truth, that one they cannot charge you with perjury for, because those are things in the past. What they might be able to charge you with is, I don't know, I mean, give me an example of something that you know he didn't do, and, well, maybe not, never mind, don't do
Can I
that.
give you an example for what they told me?
Yeah, yes, and then I'll see whether that's what I think or not. Yes.
So she said that the only reason she won't lock me up, I just want to know if it still applies.
Okay.
She said if I do two things, if I plead the fifth and I say that I killed Donovan Thomas.
Okay.
She said if I don't say them two, she will not lock me up.
All right. What was the first one?
pleading the fifth.
So taking the fifth means I might say something that gets me in criminal trouble. I might give you evidence against me that you could then use against me. That's what it means to take the fifth, is say, I am not going to give you evidence to use against me to charge me. When they give you that immunity order, immune just basically means we can't do this anymore. It's like if you get an immunization, oh, I'm not going to get the measles now, right? Because I'm immune from it. Because it's like getting you a shot that says, I can admit to a.
She's talking to him like he's 5.
On the stand, they can't charge me with it. They have said, you no longer have a privilege against self-incrimination because committed to not being able to prosecute you, not being able to bring criminal charges against you because of what you say. We cannot take that evidence and use it against you. We can't take that evidence. If you say, well, I committed some crime. Here's what I committed it with. I buried it in the yard. They can't go dig it up in the yard and then say, well, we've got this. They can't use any of that. That's why taking the fifth at this point would get you in trouble. Being held in contempt is what we
So where they don't have
formally call it.
they facts together, like they saying something they don't know what they're talking about, and then they ask me about it.
They can ask you about anything they want to. If in your answer you admit to a crime, they cannot charge you with that crime. Now, if you admit to a crime and they have evidence that is pretty certain that you did not commit that crime, for instance, somebody gets robbed yesterday and they have proof that you were in Europe yesterday. There's no way you could have committed that crime, but you say, yeah, I committed that crime yesterday. That was here in Atlanta when they know you were in Europe and they got video of you in Europe and you sent a postcard that said, I'm having fun in Europe. That would be proof that you're lying. And so that they could charge you with perjury for, okay? Or false statements for.
Okay.
Okay? So what I want to know from you is when we have the jury back on Monday and you're still under subpoena, so you're still obligated to come in. I'm asking you now, when they're like, all right, we're calling Kenneth Copeland, are you going to say, okay, ask me what you want to ask me. I'll tell you whatever I'm going to tell you. Or are you going to say, nope, I don't care if you throw me in jail. I'm not saying a word. I am not getting on the stand.
It depends on how I wake up.
Okay.
Woody needs to start a YouTube channel of just talking, like just chilling, smoking or something.
All right. Well, then we will just revisit it on Monday morning. So plan to be here at 8:45 on Monday morning. You're free to go.
He looks pissed. I'm gonna wait until Quindarius is the next witness in court because this is just the lawyers hashing it out, what's gonna be shown to the jury. So whatever, we'll just wait until that happens. That's pretty much it for today. Jury comes back on Monday apparently. Judge still has to rule on a lot of things, so she's got to figure that out pretty soon here. Motions for mistrial, motion for a fair trial. Hit subscribe, join the channel. Membership's only 10 cents per day. Love you guys, peace out.